Hi guys, what's up? So let's begin with the video. So from the title itself, it is quite visible, and it is quite easy to know that what we will be discussing and what will be the agenda of this video. So yes, primary evidence, that is section 57 of the Bharatiya Saksh Adhiniyam, which is corresponding to the section 62 of the Indian Evidence Act, which was the earlier, like before 2023 or before it came into force, like in 2024. Before it was Indian Evidence Act. So let's begin. Primary evidence. So actually, to give just the background, if you have to prove something before the court of law, then you have three things. Like you can prove it by three things, like oral evidence, documentary evidence, and material evidence. So these two types of evidence are given in the book explicitly, and third type of material evidence is actually given in indirect form in a particular provision. So yes, oral evidence, as the name itself suggests, and you better know, and the documentary evidence, there are two types: primary evidence, secondary evidence. So we are dealing today in this video is about primary evidence, which is section 57. So let's read it from the bare act itself. Sorry if there will be some background noise, please ignore it, try to ignore it. Section 57, primary evidence. Primary evidence means the document itself produced for the inspection of the court. It means the document itself, it is the original document. Like for a sale deed, if there are sale deed executed between two persons, then that original sale deed will be the primary evidence. And let's read the explanation, which is the important. And after reading that those explanations, we will be quite clear that what is exactly the primary evidence, and in what circumstances and different circumstances what does it mean. So explanation 1: where a document is executed in several parts, each part is primary evidence of the document. So if it is executed in several parts, for example, there are two persons, A who is residing in Mumbai and B who is in Delhi. So these both people are executing our document, and for example, there is a document X, and which the signature of both the parties is there, A and B, because they both are residing at different places. So they want the document to be kept in their custody, like they want the original. So it is executed in several parts, in two identical documents, and in both documents it is having signature of both the parties. Like in X document it is having signature of both A and B, and in Y document it is having signature of both A and B. So these both are identical document, and these both are original. So if A wants to produce somewhere the original document, he can produce that document, and the same goes with the B. If he want to produce the original document, he can produce the document which is in his possession. So these both are original document. This is with respect to explanation 1. And explanation 2, where a document is executed in counterpart. Focus on the counterpart. After it, each counterpart being executed by one or some of the parties only, each counterpart is a primary evidence as against the parties executing it. So let's explain. I will explain you with an example, so it will be quite easy to break down. So for, let's say, there are persons, and I will always choose the example of A and B. So if you didn't got anything, then please rewind the video, and then definitely you will understand it. What does that mean? So for explanation to A and B. So for example, A make a offer, and B, he make a offer through a document, through a letter, and he gives it to B, and B accepts it, and he gives the acceptance to A, right? So A is giving the offer, and though that offer, the document of offer, he is sending or transmitting to B. B keeping the offer itself, and B is sending the acceptance to A. So therefore the contract is formed between A and B. So here, what does the counterpart mean? So the document which is in the possession of A, and the document which is in the possession of B, and the offer which A made is in possession of B, because A sent the offer to B, and it is signed by A, and the custody of it is having in the possession of B. So the offer now rests with B, and the acceptance now rests with A. So here the counterpart means is the offer is the counterpart of acceptance, and vice versa. Acceptance is the counterpart of offer. So if now let's make the position clear, A is having the acceptance document, and B is having the offer document. And in the initial A is having the offer which is sent to B, and now B is having the offer. So this is the clear position. A is in the possession of acceptance document, B is in the possession of offer document. So if A wants to prove the original evidence, like if court wants to the for production of primary evidence, original document, so the document is which is in possession of A, which is the acceptance document, it is the original primary evidence against B, because B signed it and it is in the possession of A. So A is the offer, the acceptance is the original document of primary evidence against B regarding that contract, and B is with the offer which is in the possession of B. It is the primary evidence against A because it has bearing the signature of A and it is in the possession of B. So these both are counterpart document. They both are executed indifferently, but they can prove the particular document against the other party and not against third person, because it is bearing the signature of other party, and it is having the custody of it is having the a particular party. So any third party is against it will not be proved against any third party, because there applies a privity of contract, because both the person are having the signature and it is with regard to that contract only which they are proving. So yes, to say in the layman language, you can also write it like, make note of it, जो document तुमने sign किया है वो तुम्हारे अगेंस्ट प्राइमरी एविडेंस है, बिकॉज ए ने साइन किया था ऑफर एंड ही ट्रांसमिटेड टू बी, सो बी कैन प्रूव द प्राइमरी एविडेंस अगेंस्ट ए बिकॉज इट इज बियरिंग द सिग्नेचर ऑफ ए. दिस इज विद रिगार्ड टू explanation 2. I took a lot of time because it requires a lot of discussion so that you can easily get it. And now moving towards the explanation 3, where a number of documents are all made by one uniform process, as in the case of printing, lithography, or photography. Each is primary evidence of the content of the rest. So for example, there is a marriage card. You have created a draft on your computer and you just did that. You created a draft and yes, so you create a draft and you get print out, and this is the original document. This is the primary evidence. And then you want the 1,000 printout of it, because you want the marriage card to be distributed in the public for the purpose of invitation to your marriage. So those 1,000 printout of the same template, of the one template of one marriage card, that 100,000 printout will not be the primary evidence against the one original, which is the first template which you have printed in the initially. So that initially printout of the template of original marriage card, that's the primary evidence, and those 1,000 printout of it is not the primary evidence, though they are the primary evidence against the other. Like one of the 1,000 printout is a primary evidence against 999 printouts. Okay, so this is with regard to explanation 3. And one more thing, if there is a mistake in an original template, then it can be rectified in other printout. So therefore the original one is always be different, and the 1,000 printout or the other XYZ number of printout will always be different. So yes, this is with the explanation 3. And now moving towards the explanation 4, which says that where an electronic or digital record is created or stored, and such storage occurs simultaneously or sequentially in multiple files, each such file is primary evidence. So let's take an example of an email. For example, you write an email and it is saved on your device firstly, and when you send the recipient or the other person, then it is saved in their device also, and so it is now saved in two devices. And there is also third device which is saved, which there is a server of Google from which, like, you are writing mail, for example Gmail, then it is also saved in the Google server. So it's saved at three places, and these three the emails, which the three places which the email has already been saved. So these three devices are the primary evidence against themselves. Like first evidence, like these all three are the primary evidence. Like with the email which is saved on a device, the email which is saved on the recipient device, and on the Google server. These all the original document, and these all are the primary evidence. Let's moving forward the explanation 5. You can read from the direct. I will just give you an example so that it will straight penetrate in your head, and you will just get a good idea of it with an example. So it says that custody talks about the custody. Like if some document is in the custody of someone, then it is the primary evidence. Please leave the please ignore the background noise. So yes, for example, if you are having the metro card, obviously, if you are staying in Delhi or some metropolitan area, so if you are punching the metro card in the device, or when you just check in to the punching machine, so that punching machine saves your data, and it is saved on a particular server. So if a court wants the production of that particular data, then they can summon the server, and it is the primary evidence. And same goes with the boarding pass. When you just check in while boarding the flight, you must be having the boarding pass. So they actually scan it with a machine. So that machine saves extract out the information about the boarding pass, and it saves in their server, so that if anyone wants to summon that original document, it can be summoned easily. Now moving towards explanation 6, where a video recording is simultaneously stored in electronic form and transmitted or broadcast or transferred to another. Each of the such stored recording is primary evidence. For example, this particular video, and I am making this video on YouTube. I am saving it in my gallery. So this is the primary evidence, this is the original. And when I'm transmitting it to the YouTube server and they are showcasing to the larger public, then that is the primary evidence. If you want to produce it in the court of law, saying that to prove the original to prove the original video, then you can very well produce this video from the YouTube, because it is the primary evidence. This is with explanation 6. And now explanation 7. When an electronic or digital record is stored in multiple storage spaces in a computer resource, each such automated storage, including temporary files, is primary evidence. For example, MS Word, you are creating a file, you are just drafting anything, or for example a bail petition for that matter, and you are saving it on the Google, and you are taking printout. So it is saving on the MS Word. So that MS Word is the primary evidence, right? And it is like most of the times it saves automatically. So if it is saving automatically, then also it is a primary evidence. You can produce in the court of law for proving your original document. It will be the primary evidence. So this all with regard to primary evidence. One thing again I would like to throw light on the explanation 2, which is the counterpart. So X document is the counterpart of Y. So X can be produced and as the primary evidence only against Y, and Y will be the primary evidence against X. And if they want to produce it separately, then that X document is the secondary evidence, and similarly Y document is the secondary evidence. So this is with regard to section 57 of the Bharatiya Sakshar Adhiniyam. I hope you get it. If there is any doubt or you need some clarity on any point, you can just drop a comment on the chat box, and I will definitely entertain it in the next video. If you like it, then please do like, and if you want some improvement on my part, like which part you didn't get it, so please do mention in the comment box. Please criticize me. I will appreciate you.